Good afternoon, students. Today we will see a new chapter for the law that we already completed the first module till performance of the contract, unit 9. Today we are going to see discharge of a contract. So what is meant by discharge and what are its essentials? That we are going to see now. So what is a discharge of a contract? Discharge of a contract means the termination of the contractual relationship between the parties. So, discharge. The contractual relation between the promiser and the promisee ends. Termination of the contractual obligation between both the parties, it is called the discharge of a contract. So, in simple sense, it is. So, when a contract is discharged, the right and obligations created by it, both the parties have some rights and the obligation, both cease to exist, means stop. So, that is, what is that? It is the termination of the contractual obligation or the right between both the parties. It is called the discharge of a contract. So, a contract may be discharged by the following modes. പല തരത്തിൽ വേണമെങ്കിൽ contract between both the parties may be discharged. So in different ways, we will look into that. What are the ways in which a contract is to be discharged? One is by performance. So what are the aspects with this? So one is this performance. When the parties to a contract fulfill the respective obligation of contract, then the contract gets discharged by performance. So when the parties to a contract fulfill their respective obligation, okay, then the contract gets discharged by the performance. When the contract is performed, fully, the contract ceases and the parties are discharged from any further liability. Full ആയിട്ട് അതിന്റെ പെർഫോം ചെയ്തിട്ടുണ്ടെങ്കിൽ it is a case with regard to what? Discharged fully means termination of the contract at the full extent. So that is, when the contract is performed fully, the contract ceases and the parties are discharged from any further liability. ഇനി വീണ്ടും ഒരു ബാധ്യതയും ഇല്ലാതെ the parties are to be discharged. Performance of a contract may be actual performance, ശരിയായിട്ട് പെർഫോം ചെയ്യുന്നത്. Second one is attempted performance. That we already see as tender in the previous chapter. So, what is an actual performance and what is an attempted performance? Actual performance where both the parties perform the obligation exactly as per the terms of the contract. Either the promiser as well as the promisee do their duty as per the thing mentioned in the contract. It is a case of actual performance, means actually the contract is performed there. In simple sense, the contract is performed there. While attempted performance or tender means promiser offers to perform the contractual obligation and promisee is not willing to accept such a performance, the contract is deemed to be discharged by attempted performance. Like എയും ബിയും കൂടെ കോൺട്രാക്റ്റിൽ ഏർപ്പെടുകയാണെങ്കിൽ എ is the promiser and he is willing to do this, but B is not accepting that performance. In such a case, discharged by attempted performance. Both A and B do their duty. Final, it is a case of actual performance. So, attempted performance and actual performance under the by performance, discharged by performance. So, when the parties to a contract fulfill their respective obligation of contract, then the contract is get discharged by the performance. When both the parties perform their obligation and finish it, then that is a discharge by performance and both the parties are free from the liability to do anything else. So that is what? Discharge by performance. So actual performance and attempted performance. Both the parties, as per the thing mentioned in the contract, both the parties perform their obligation or the rights. It's a case of contract or discharge by actual performance. While attempted performance or tender means when one of the party, the promiser, willing to do the duty, while the promisee is not accepting such a performance, it is a case with regard to discharge by attempted performance. Hope you know this meaning of these two. So, discharge by performance, two types are there. Discharge by performance, two types are there: actual performance and attempted performance. Next, discharge by agreement. So, discharge by performance is number one. So, there are several ways in performing the discharge of the performance also. So, the contract is to be discharged by performance. Both the parties must have fulfilled the obligation. Then it is a case of discharge by performance, but that is the actual performance. While if one party, the promiser, agrees or willing to do his duty or rights or obligation, but the other party is not at all willing, means the promisee doesn't accept such a performance, it is a case of discharge by attempted performance. Second one, discharge by agreement. Discharge by agreement. So what is that? A contract is created by an agreement. A contract, two parties by law. Agreement enforceable by law is called a contract. At the first class, I already told you or taught you regarding this one. So therefore, it may be terminated by the same method. There are various methods or modes by which a contract may be discharged. One is novation of the contract. Novation. What it means? Novation means substituting a new contract in the place of an old contract. So substitution. ഒന്നിന് പകരമായിട്ട് വെക്കുക. ഒരു കോൺട്രാക്റ്റിന് പകരമായിട്ട് വേറൊരു കോൺട്രാക്ട് വെച്ചാൽ it is a case of novation. Sometimes the same parties may adopt a new contract in the place of an old one, and there could be a change of the parties. Parties could be maybe changed. So the essential requirement of novation is that this new agreement is entered into consideration for the old agreement. It is treated as novation only if it is entered into at the time when the old agreement is remaining valid. When the old agreement is valid, then only this substitution will take place. That is novation. ഒന്നിന് പകരമായിട്ട് വേറൊന്ന് വെക്കുകയാണെങ്കിൽ it is a case of which one? Novation. So novation means substituting a new contract in the place of an old contract. Okay. Sometimes the same parties may adopt a new contract in the place of an old one, or there could be a change of the parties. Then the essential element or requirement of novation is that this new agreement is entered into in consideration for the old agreement. For example, A owes money to B under a contract. As per a contract, A is owing some money to pay to B. It is agreed between A, B and C that B shall accept C as his debtor in the place of A. So, what is that? It is agreed between A, B and C. Actually, there is party who A and B only, but at the same extent, C is also his debtor in the place of A. When this agreement is entered into, the old debt of A to B comes to an end and a new debt from C to B has been contracted. അതാണ് പകരമായിട്ട് വന്നത്. A to B ആയിരുന്നു കൊടുക്കേണ്ടത്. Aയുടെ debtor ആയിട്ട് C join ചെയ്യുകയാണെങ്കിൽ there should be a contract between B and C. So that is the case with the novation. A substitution in place of an original contract. If the term specified or the time to be undertaken to do that performance is mentioned there, then only, if that is valid, then only this novation take place or substitution take place. So that is the first point. Substitution means substituting a new contract in place of the old contract. Number two, by what is that? Rescission. 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 Rescission means parties to a contract may decide to cancel. Resist means cancel. Cancel a contract on the basis of the mutual consent and consideration. Then it is called a rescission. So rescission means what? Parties to a contract may decide to cancel a contract on the basis of the mutual consent and consideration. രണ്ടുപേരും തമ്മിൽ agree ചെയ്യാണ് that we will finish this one at the earliest. So there should be a mutual consent or consideration between the two parties. So that rescission happens, the original contract then get discharged. Cancellation of the contract between by mutual consent or consideration between the parties, that is called the rescission. Agreement discharge ചെയ്യുകയാണെങ്കിൽ അതിൽ ഒന്നാമത്തെ കേസ് ഒന്നിന് പകരമായിട്ട് വെക്കുകയാണെങ്കിൽ so the contract get discharged. Rescission രണ്ടാമത്തെ കേസിൽ എന്ന് പറഞ്ഞാൽ എന്താ, cancellation of the original contract between the parties mentioned by mutual consent or consideration, that is the rescission. Third is alteration, changing the terms, that is not at all acceptable, then it is a case where the discharge by agreement. So alteration of contract take place when one or more of the terms of the contract is or are means almost all the terms of the contract are altered, or one or more of the terms is altered, okay, by mutual consent of the parties to a contract, then the old contract is discharged and the parties become bound by a new contract. So here discharge by agreement, under that one is novation, next is rescission, cancellation. Novation means substitution, rescission means cancellation, alternation means changing. So alteration of a contract takes place when one or more of the terms of the contract is or are altered by the mutual consent between the parties. Therefore the old contract becomes cancelled and the new one will be enforced by law. Adana under the alteration. Fourth is remission. What is remission? It means the acceptance of a lesser performance than what was due under the original contract. അതായത് ഒറിജിനൽ കോൺട്രാക്റ്റിനകത്ത് പറഞ്ഞ ടേംസിൽ നിന്നും പകരമായിട്ട് അതിനെ അത്രയും ഇമ്പോർട്ടന്റ് ആയിട്ടുള്ള അല്ലാതെ ഒരു സ്മോൾ ലെസർ പെർഫോമൻസ് ഓഫ് ദി കോൺട്രാക്ട് ആണ്. അതായത് ഡ്യൂട്ടീസ് പറയുന്നത് വളരെ കുറച്ചാണ് അവരുടെ, അതിന്റെ ഇമ്പോർട്ടൻസ് കൂടുതലല്ല. So that is the case. An example for remission would be acceptance of a lesser sum than what was contracted for in discharge of the whole of the debt. 10,000 തരേണ്ടതിന് വരെ 5,000 അത് കുറച്ചു. So there is a lesser performance. 5,000 മാത്രം കണ്ടെത്തിയാൽ മതി. ഫോർ എക്സാമ്പിൾ എ ബിക്ക് 10,000 കൊടുക്കാനുണ്ടായിരുന്നു. ബി പറയാണ് that need to pay only 5,000 lesser. So the performance will be less. So that is the case with regard to remission. Remission means reducing the value of the contract. That is remission means acceptance of a lesser performance. അവിടെ ഒരു lesser performance അല്ലേ കണ്ടേ, എ ബിക്ക് കൊടുക്കാനുള്ളതിന് കുറച്ചൊരു എമൗണ്ട് തന്നാൽ മതി എന്ന് പറയുകയാണെങ്കിൽ then he is happy, A is happy because only a lesser performance is there. So acceptance of a lesser performance than what was due under the original contract. An example for remission would be the acceptance of a lesser sum than what was contracted for in discharge of the whole of the debt. Then another one is by waiver. What is waiver? Debt that you already studied. It is a deliberate abandonment of the rights which the parties to the contract mutually have against each other. No consideration is necessary for waiver. ഒരു പ്രതിഫലവും ഇല്ല. Waiver എന്ന് പറഞ്ഞാൽ whether to do or not to do, or the happening or not happening of that event. Based on the happening, the money is to be paid back to the other. If it is not happened, no need to pay anything. That is a waiver or wavering agreement. So it is a deliberate abandonment of the rights which the parties to a contract mutually have against each other. No consideration is necessary for waiver. Another point is merger. Merger and acquisition, there is a term. So merger takes place when an inferior right accruing to a party under a contract merges into a superior right accruing to the same party under same or some other contract. For example, through an example I will explain to you. T, a tenant was holding a property under a lease agreement. T എന്ന് പറയുന്ന വ്യക്തി ഒരു ടെനന്റ് ആണ്, അയാൾക്ക് a property is to be held, ഒരു സ്ഥലം അയാൾ കൈവശം വെക്കുന്നുണ്ട്. ഓക്കെ, അണ്ടർ എ ലീസ് എഗ്രിമെന്റ്. പാട്ടത്തിന് കൊടുത്തിരിക്കുകയായിരുന്നു. ഓക്കെ, പാട്ടത്തിന് എടുത്തിരിക്കുന്ന ഒരു ഇത്. He later buys that property. ആ സാധനം അതെന്ത് ചെയ്തു? He later buys, അത് വാങ്ങിച്ചു. ഓക്കെ, then the right of the tenant merges into the right of the ownership. ശരിയല്ലേ? ടെനന്റ് പാട്ടത്തിന് എടുത്തിരിക്കുന്ന സ്ഥലം later he buys, then he will be the owner. So merger എന്ന് പറഞ്ഞാൽ എന്താ? ആദ്യം സ്മോൾ ഇമ്പോർട്ടൻസ് ആയിരുന്നത്, അല്ലെങ്കിൽ അങ്ങനെ ഒരു കേസ് ആയിരുന്നത്, പിന്നെ പുള്ളി അത് മേടിച്ചെങ്കിൽ that small what is that small right will become a big right for that particular person. So inferior right accruing to a party becomes a superior right, like a tenant become the owner. For example, ഒരു പാട്ടത്തിന് എടുത്തിരുന്ന സ്ഥലം നമ്മൾ എന്ത് ചെയ്യണം? പാട്ട തുക കൊടുക്കണം, റെന്റ് കൊടുക്കണം അതിന്. ഇനി അയാൾ ഓണർ ആയാലോ, no need of paying the rent, it is his property. So the inferior right become a superior right there. A tenant become an owner there. So that is the merger. So these are the discharge by agreement. So discharge by performance, actual performance, attempted performance. Discharge by agreement, novation. Then novation means substitution. Rescission means a cancellation. Alteration means to change. Remission. Then waiver and merger. So once again, what is that? Novation means what? Substitution of the new contract, the substitution with a new contract for the old contract. So the old contract discharge should be finished because the new contract come into existence. Rescission means what? Cancel by mutual agreement between the parties. Then alteration. Alteration same as agreement between the parties is there, mutual consent between the parties are there, they can change it. Then remission means acceptance of a lesser performance than what was due under the original contract. അതായത് കടം കൊടുക്കാൻ ഉണ്ടായിരുന്ന ഒരു കേസിൽ അത് കടം കുറച്ച് കൊടുക്കാൻ പറഞ്ഞാണെങ്കിൽ it is a case of lesser performance. So the other person sure they will accept it because only less need to pay. That is the remission. Waiver, abandonment of the right. എന്തായാലും അവകാശത്തെ ഹനിക്കുന്ന രീതിയിലുള്ള. Okay, so in such a case the parties to a contract may mutually agree in between the things. So that is the waiver. And next is the merger. Inferior right of a contract becomes a superior right in the another contract or some other contract or the same contract. For example, T is a tenant of a particular property and later he buys that property, then before that he is the tenant and now become the owner of that property. So പാട്ട തുക കൊടുക്കുന്ന ആള് കുറച്ച് കഴിഞ്ഞപ്പോ അതെന്തായി? ആ ഒരു സ്ഥലത്തിന്റെ ഓണറായി. അത് ഡിനോട്ട് ചെയ്യുന്ന എന്താ? merger means changing from inferior right to superior right. So these are the discharges by performance and by agreement. So discharge by performance, attempted performance or tender means what? Performance to be done by one of the party, willing to do the one by one of the party, while the other party refuses to accept it, or he is not in a way acceptable with the performance of the previous of the promiser or the party to whom to willing to do. It is a case of attempted performance or a tender. While the accepted performance is what? Both the parties accept each other with the performance, and then such a case the performance will be finished. That is the discharge by performance, attempted and accepted performance. Next we see by agreement, novation or substitution, rescission or cancellation, alteration or to change, remission means what? Lesser performance to be accepted rather than a big one, means in the same contract. Then waiver and also abandonment of the right, and also merger, inferior right to superior right. This is the second one, discharge by agreement. So two types, discharge by performance and discharge by agreement. Next is discharge by impossibility of performance. What is impossible? So impossibility of performance. അതായത് നടക്കാൻ പാടുള്ളത്. So an agreement to do an act impossible, it should be void from the very beginning itself. അപ്പോൾ ഒരു പ്രവൃത്തി അത് ഇമ്പോസിബിൾ, അതായത് ഇല്ലീഗൽ ഇൻ നേച്ചർ ആയിട്ടുള്ള ഒരു ഐറ്റം നമ്മൾ ചെയ്യുകയാണെങ്കിൽ it is there should be some impossibility, isn't it? So that is, So impossibility by performance. So what are its? Impossibility known to the parties at the time of making the contract. Very simple term. Impossibility known to the party. These are known to the ready, or they know that this will happen. This impossibility will happen. So impossibility, and it should not be happened also. Okay, and impossibility known to the parties at the time of making the contract. For example, any agreement entered into for the purchase or purpose of doing an act which is legally or physically impossible is a nullity. Means it cannot be going to happen. അത് ഉറപ്പാണ്. അതായത് general opposed to the public. പബ്ലിക്കിന് ഒപ്പോസ് ആയിട്ടുള്ള എന്തെങ്കിലും ഒരു കാര്യം നമ്മൾ ചെയ്യുകയാണെങ്കിൽ ഷുവർ ഇറ്റ് ഷുഡ് ബി impossibility of performance, because both the parties should know that this will one day will be impossible to do. So that is impossibility known to the parties at the time of entering the contract. So first case is that one, impossibility known to the parties at the time of making the contract. Then second case, impossibility unknown to the parties at the time of making the contract. So first case is what? That known to the parties. At the time of making the contract, impossibility should be known by the parties. Second case, doesn't know. So what is that? Where at the time of making the contract, both the parties are ignorant of such an impossibility, the contract is void on the ground of mutual mistake. For example, A agrees to sell his cow to B. But unknown to both the parties, the cow was dead at the time when the contract was entered into. Therefore, the contract is void on the ground of mutual mistake. രണ്ടുപേരുടെ വഴിയും തെറ്റുണ്ട് ഇല്ലേ? കാരണം A agrees to sell his cow to B, but unknown to both the parties, the cow was dead. When the time of entering in the contract between A and B, at that time itself, the cow was dead, so that both are making a mutual mistake. അങ്ങോട്ടും ഇങ്ങോട്ടുള്ള ഒരു തെറ്റാണ് കാണിക്കുന്നത്. So that such a case, the impossibility unknown to the parties at the time of making the contract. Third is impossibility known to the promisor alone. Promisee doesn't know that this is going to happen or this will not happen. Promisee അറിയില്ല. If the promisor alone is aware of the impossibility of the performance at the time of making of the contract, he shall have to compensate the promisee for any loss which such promisee sustains through non-performance of the promise. അങ്ങനെ പെർഫോം ചെയ്യാതിരുന്നിട്ടുണ്ടെങ്കിൽ if the promisee has to undergo some loss, then the promisor need to compensate for that. That is the third one. Impossibility known to the promisor alone. പ്രോമിസർക്ക് ഒറ്റയ്ക്ക് ഇത് അറിയായിരുന്നു ഇങ്ങനെ ഒരു സംഭവം നടക്കും എന്നുള്ളത്. ഓക്കെ, അങ്ങനെ ഒരു സംഭവം നടക്കും എന്നുള്ളത് അറിയായിരുന്നുവെങ്കിൽ then in such a case impossibility known to the promisor alone. So if the promisor alone is aware of the impossibility of the performance at the time of making of the contract, he shall have to compensate the promisee for any loss which such promisee sustains through the non-performance of such a promise. അതായത് ചെയ്യാതിരിക്കുകയാണെങ്കിൽ പ്രോമിസർക്ക് അറിയാം. So in case any loss is to be on the promisee's side or loss is to be bared by the promisee, the promisor need to compensate for such loss. That is the third one. Then fourth is what? Impossibility which arises subsequent to the formation of contract. After the contract is entered into, such impossibility will be happening. Then in such a case, what will be the action? When a contract which was capable of performance at the beginning, subsequently due to the change of the circumstances becomes impossible, then the contract becomes void. So contract was capable of performance. At the time of entering the contract, it is capable to perform that one. Later on, changed it so that impossibility occurs. So what is that? The contract becomes void. However, mere difficulty of performance or impossibility generally is not a ground for cancelling any contract. Only when the impossibility is caused by circumstances beyond the control of the parties, the contract gets discharged. രണ്ട് പാർട്ടീസിന്റെയും കൺട്രോളിൽ നിൽക്കുന്നതല്ലാതെ സാഹചര്യത്തിനനുസരിച്ച് ഇമ്പോസിബിലിറ്റി ആവുകയാണെങ്കിൽ the contract will become discharged. So this doctrine is known as doctrine of supervening impossibility or post-contractual impossibility. This will always ask me in the question exam, doctrine of supervening impossibility. Doctrine of supervening impossibility. So what is that? So what is that? Impossibility that arises subsequent to the formation of the contract. After forming or after entering into the contract, due to the circumstances, impossibility occurs. In such a case, what? The contract will become void. So mere difficulty of performance or such an impossibility generally is not a ground for cancelling the contract. അതായത് ഇങ്ങനെ ഒരു ഇമ്പോസിബിലിറ്റിയുടെ പേരിൽ ഒരു കോൺട്രാക്ട് ക്യാൻസൽ ചെയ്യാൻ പാടില്ല. പകരം only when the impossibility is caused by the circumstances, ചില സാഹചര്യങ്ങൾക്കനുസരിച്ച് ഈ impossibility നടക്കും, അങ്ങനെ വന്നു. So that it is not beyond or it is circumstances beyond the control of the parties, then the contract will become discharged, and such a discharge is called a doctrine of supervening impossibility or post-contractual impossibility. So impossibility arises subsequent to the formation of the contract, then in such a case the contract will become void due to the circumstances. Such circumstances that is beyond the control of the party get discharged. It is called a doctrine of supervening impossibility. Hope understand this point, that after entering into a subsequent after entering into the formation of the contract, the impossibility occurs due to the circumstances. Excuse me, the contract will become void. Okay, in such a case it is beyond the control of the parties, so that it gets discharged. It is a case of doctrine of supervening impossibility. So what are under the impossibility of performance? Impossibility known to the parties at the time of entering into the contract, impossibility not known to the parties at the time of entering into the contract. Third one is impossibility that arises subsequent to the formation of the contract, or doctrine of supervening impossibility or post-contractual. Another name is post-contractual impossibility. Post-contractual impossibility. So there are a few situations where a contract gets discharged by the supervening impossibility. One is destruction of the subject matter of the contract. അതായത് അതിന്റെ സബ്ജക്ട് മാറ്റർ തന്നെ ഡിസ്ട്രോയിഡ് ആയിപ്പോയി. Destruction of the subject matter of the contract. When the subject matter of a contract subsequent to its formation is destroyed without any fault of the parties to the contract is get discharged. അതായത് മെയിൻ ഐറ്റം എന്താണ്? അതിന്റെ സബ്ജക്റ്റ്. ആ സബ്ജക്റ്റ് തന്നെ നശിപ്പിക്കപ്പെട്ടു പോവുക അല്ലെങ്കിൽ നശിച്ചു പോവുക എന്നുണ്ടെങ്കിൽ it get destroyed, then it is a case under this supervening impossibility get discharged. So the few situations where the contract get discharged is destruction of the subject matter of contract. Destruction of the subject matter of contract. So when the subject matter of a contract gets destroyed subsequent to the formation, means after the formation of the contract, in such a case it is not without not with the control of the party, means beyond the control, without any fault with regard to the parties to the contract. Such case it gets discharged. We will see if there is any case or not for this. So this is the case. A music hall was hired for a series of concerns. A music hall for a series of concerns, it was get hired, while subsequent to the contract, the building was destroyed by fire. Means after agreeing with the terms and conditions of the contract, later on the hall was destroyed by fire. Then what to do? It get discharged, because the court held that the contract become void due to the destruction of the hall. So that is destruction of the subject matter. The subject matter is what? A music hall. A hall then destroyed after getting into the contract. Then it is not with the fault of any of the party, but due to the circumstances it happened. In such a case, the contract will become discharged or void due to the destruction of the whole. So that is the destruction of the subject matter of the contract. Second, non-existence or non-occurrence of a particular state of thing. So non-existence, നിലനിൽക്കുന്നില്ല അല്ലെ non-occurrence, നടക്കുന്നില്ല of a particular state of things. B point, non-existence or non-occurrence of a particular state of thing. Non-existence or non-occurrence of a particular state of thing. So what is that? Sometimes a contract may be entered into on the basis of a continued existence or occurrence of a particular state of thing. If there is any change in the state of things, or if the state of things which ought to have occurred doesn't occur, the contract will be discharged. This I will explain it through a case. Krell versus Henry, 1903. H hired a flat from K. H is the person hiring a flat from K for June 26 and 27, 1902 for witnessing a coronation procession of King Edward VII. K knew of H's purpose of hiring the flat. The coronation procession was cancelled due to the illness of the king. The court held that H was excused from paying the rent on the ground that the existence of the procession was the basis of the contract. അല്ലെ ആ ഒരു കൺസേർട്ട് നടത്തും എന്നാണ് പറഞ്ഞത്. അതിനു വേണ്ടിയിട്ടാണ് എച്ച് എന്ത് ചെയ്തത്? He hired a flat from K. But the concert is not at all happening. Non-occurrence of that thing in such a case doesn't need to pay anything to K. That is the case. So its cancellation discharged such a contract. The court held that H was excused from paying the rent on the ground that the existence of the procession was the basis of the contract. So that is the non-existence or non-occurrence of the particular event or state of thing. That is the second closure or provision. A contract enter ചെയ്യുന്നുണ്ട് based on the subject matter. If the particular state of thing is not happening or non-occurrence or non-existing itself, means doesn't exist or not occurring or not happening, in such a case, what is the issue or what is that? Contract will become void. അതിനൊരു എക്സാമ്പിൾ പറഞ്ഞത്, എച്ച് എന്നുള്ളൊരു വ്യക്തി കെ എന്ന വ്യക്തിയിൽ നിന്ന് ഒരു ഹൗസ് പാട്ടത്തിനെടുക്കുന്നു, റെന്റിനെടുക്കുന്നു for 2 days in order to watch a coronation procession of King Edward VII. Later, the king became ill, so that it was cancelled. The procession itself was cancelled. That is non-occurrence or non-existence. So, no need to pay anything, as the court held that H was excused to pay any rent to K because the non-occurrence or non-existence of the state of the thing, that concern is not at all happened, so that nothing to pay. Adana dinathe case law. Then third is the death or personal incapacity. 3, the death or personal incapacity, means incapable to do that particular performance because of the person is not at all there. Clear? So where the performance of a contract depends on the personal skill or the qualification of a party, the contract is discharged on the illness or incapacity or death of that party. ആ വ്യക്തിയുടെ അഭാവം, there is no one to perform the contract. Nobody is there to perform the contract. So the incapacity or incapability or the illness or the death of the person to perform the contract is not available, so that the contract get a discharge. Case law, Robinson versus Davison. An artist undertook to perform at a concert on a particular day, but she couldn't perform on the day due to serious illness. It was held that the artist was not liable to pay the damages as he became ill. ഒന്നെങ്കിൽ അസുഖം ബാധിച്ച് അല്ലെങ്കിൽ മരിച്ചു പോവുകയോ അല്ലെങ്കിൽ personally incapable to do that act, so that what is the issue? Or in such a case, contract becomes discharged. Then next is what? C or D, death or personal incapacity. Then fourth one is, these are the doctrine of supervening impossibility. So change of law or stepping in of a person with statutory authority. So നിയമം മാറുക അല്ലെങ്കിൽ stepping in എന്ന് പറഞ്ഞാൽ ഒരാളെ ഉള്ളിലോട്ട് തള്ളിയിടുക. ഓക്കെ, മീൻസ് കേറ്റുക, അഡ്മിറ്റ് ചെയ്യുക. ഓക്കെ, സ്റ്റെപ്പിംഗ് ഇൻ ഓഫ് എ പേഴ്സൺ വിത്ത് സ്റ്റാറ്റ്യൂട്ടറി റൈറ്റ്സ്, പദവികൾ കൊടുത്തുകൊണ്ട് ഒരാളെ അഡ്മിറ്റ് ചെയ്യുക എന്നുള്ളത്. സംടൈംസ് after the formation of a contract law may undergo some changes. There should be some clauses to be added up in the law, or a statutory authority that intervenes, which may make the performance of the contract impossible. Then the contract gets discharged in such situations. For example, a property to be sold under a contract, if acquired by the government, cannot be sold and the contract gets discharged due to the intervention of the government. ഇവിടെ പറഞ്ഞ എന്താന്ന് വെച്ചാൽ, stepping in of the government to look after that property. For example, a property to be sold under a contract, but when they enter into the contract, at the same time the government intervenes the day-to-day activities, or that government has to look out the day-to-day activities of that particular contract or that particular property, sorry, not contract, property. In such a case, this is the change in law. Otherwise, stepping of a person with the statutory rights. The rights is what? To look after that property by the government. So in such a case, it gets discharged. So case law is, some quantity of wheat kept in a warehouse was sold by A to B. A B ക്ക് കൊടുക്കാനായിട്ട് some wheat, quantity of wheat to be kept in a warehouse. But before the delivery of goods could happen, it was requisitioned by the government under statutory power, and the court held that the contract become discharged. ഈ വീറ്റ് കൊടുക്കാം എന്നുള്ള ഉദ്ദേശത്തിലായിരുന്നു എ ബിയോട് എഗ്രി ചെയ്തിരുന്നത്, ഈ വെയർഹൗസിൽ സൂക്ഷിച്ചിരുന്നത്. ബട്ട് ആ സമയത്തേക്ക് ഗവൺമെന്റ് ഷുഡ് ഇന്റർവീൻ ദാറ്റ് തിങ്. ഗവൺമെന്റ് അത് എടുത്തു. സോ ദാറ്റ് നത്തിങ് ടു ഡു, ഒന്നും ചെയ്യാൻ പറ്റില്ല. കാര്യം എന്താ? ഇറ്റ് ഈസ് ദ സ്റ്റാറ്റ്യൂട്ടറി റൈറ്റ് ഈസ് ദയർ. സോ സം പേഴ്സൺ ഹാവിംഗ് the power with the statutory rights stepping into that contract. ആ കോൺട്രാക്റ്റിലോട്ട് നോക്കാനായിട്ട് ആര് വന്നു? ഗവൺമെന്റ് intervenes. So in such a case, the contract will become discharged. Due to outbreak of war. Another point is E, or which one? 5. Outbreak of war. Yuddham. A contract entered into with the national of an enemy country is unlawful and couldn't be performed. നമ്മുടെ ശത്രു രാജ്യവുമായിട്ടൊരു കോൺട്രാക്ട് ഏർപ്പെടുകയാണെങ്കിൽ it couldn't be performed because it is an enemy country. So contracts entered into before the outbreak of war was suspended during the war and may be received after the war is over. So contracts entered into such a case, if the war is broke out, then contract will be discharged. Okay, then in such a case, before the outbreak of the war, the contract will become suspended and may be revived after the war is over. അതായത് യുദ്ധത്തിന് ശേഷം എന്ത് ചെയ്യാം? The contract may be again reinstalled. Otherwise, before the outbreak of the war, the contract will become suspended. Before the outbreak of the war, the contract will become suspended. So this is very important case. Doctrine of supervening impossibility. Destruction of the subject matter of the contract. That is one clause. Even the subject matter is destroyed, contract will cease to exist, or discharge to the contract is there. Then non-existence or non-occurrence of the state of affairs. Okay, particular state of affairs of this one. So non-occurrence or non-existence. നിലനിൽപ്പേ ഇല്ല, അല്ലെ അത് നടന്നിട്ടില്ല. In such a case, what is the case? Contract will become discharged. Then death or personal incapacity of the person. If the person becomes ill contract will become discharged, or death occurs, or the personal incapacity, incapable to perform the contract, then in such a case also the contract will become discharged. Then the change of law, due to the change of law or stepping of a person with a statutory power, rather with a huge power, big power, then in such a case that person is to be stepped into the contract, means to look after that. In such a case, what happened? Contract will become discharge, and due to the outbreak of the war, the contract is also become discharged. Before the outbreak of the war, the contract will get suspended, and after the war, maybe it is revived. Revived means again it is to be thinking and need to made it or install that one, reinstate the contract. So these are the doctrine of supervening impossibility, the right with regard to. So in continuation, the exceptions to the doctrine of supervening impossibility. So these are the clauses with regard to, or the rights with regard to, the doctrine of supervening impossibility, where the subject matter of the contract gets destroyed. Means second one is the non-occurrence of a particular state of affairs with regard to the contract is there, then non-existence or non-occurrence. ഒന്നെങ്കിൽ അത് നടന്നിട്ടില്ല, അല്ലെങ്കിൽ നടക്കാനൊട്ട് ചാൻസും ഇല്ല. പിന്നെ personal incapacity, whether the person is incapable to do, or due to the illness or to the death of the person, it gets a discharge. Then change of the, or stepping a person into a change of the law, or stepping a person into a with a statutory rights or power. അതായത് ഇപ്പൊ നമ്മൾ കണ്ടു ഗവൺമെന്റിന്റെ ഇന്റർവീനിങ് ടു ദ തിങ്സ്. അപ്പൊ അത് വരുമ്പോ എന്താണ്, ഓട്ടോമാറ്റിക് ആയിട്ട് ദാറ്റ് ഡിസ്ചാർജ് ദ കോൺട്രാക്ട്. കോൺട്രാക്ട് നടക്കില്ല, കാര്യം അത് അവിടെ ഗവൺമെന്റ് അവരുടെ പവർ എടുത്ത് ആ ഒരു എന്താ പറയുന്ന ഒരു ഓഫീസറെ വെച്ച് അങ്ങനെ നോക്കുന്നു. സോ ഒരു പ്രോപ്പർട്ടി എടുക്കുകയാണെങ്കിൽ നമ്മൾ എടുക്കാൻ പോവുക, അല്ലെ വിൽക്കാൻ ഉള്ള, അല്ലെ വാങ്ങിക്കാനുള്ള ഇതാണ്. പക്ഷെ അത് എടുക്കാനുള്ള സമയത്ത്, അതായത് എപ്പം കോൺട്രാക്ട് എൻട്രി ചെയ്യുന്ന സമയത്ത് ഗവൺമെന്റിന് ഇന്റർവീനിങ് ഇല്ലായിരുന്നു, പക്ഷെ ലേറ്റർ ഓൺ ഇറ്റ് ഗെറ്റ്സ് ഇന്റർവീൻ. So in such a case, the personal intervening is there. So the personal stepping of a person into the property of that. Then in such a case, what is that? Either the change of law or the stepping of a person, and also through the outbreak of war. If the war break out, then in such a case, what happened? If it is to be suspended before the outbreak of the war, and later on it gets installed or reinstated. That is the case. Then we see there are some exceptional cases with regard to which one? This outbreak of the war. So exceptions to the doctrine of supervening impossibility. What is that? So exceptions to the doctrine of supervening impossibility, where the scope of the doctrine of supervening impossibility is not verified. This defense can be used only in the limited situation recognized by the court or the state. The following list of exceptions is helpful in understanding the limited scope of this doctrine of supervening impossibility. One is the difficulty of the performance. How to perform it? It will be difficult to perform the contract. So one is difficulty in performing the contract. difficulty in performing the contract. So a contract is not discharged by reason of the fact that the performance is more difficult, more expensive, or less profitable than the parties anticipated. അതായത് വ്യക്തികൾ അതിനകത്തെ parties to the contract അവരെ തീരുമാനിക്കുകയാണ് it should be performed in a difficult situation. It is not at all possible to perform the thing. Then there is some exceptions to such a doctrine of supervening impossibility. The second is commercial impossibility. Commercial impossibility. Sometimes sudden fluctuations in the market or outbreak of a war or a steep rise in the price of the raw materials may make a contractual obligation that is less profitable, but on these grounds a contract cannot be avoided. Due to the outbreak of a war or a steep rise in the price of material, അസംസ്കൃത വസ്തുക്കളുടെ raw materials in the price കൂടുന്ന കേസിലൊക്കെ there should be some contract to be performed with this less profitable concern. In such a case, this doctrine of supervening impossibility to be having exception. So that is the commercial, വാണിജ്യപരമായിട്ടുള്ള impossibilities. One is difficulty of performance. അത് perform ചെയ്യാനേ പാടാണ് എന്നുള്ളൊരു കേസ്. Then commercial impossibility. Then impossibility due to failure of a third person. ഒരു മൂന്നാമതൊരു വ്യക്തിയുടെ ഇടപെടൽ കൊണ്ട് something impossible happen. Sometimes when the contract is entered into, the promisor might have relied on the performance of a third person, then the contract won't become void even if the third person fails to perform. Why it is impossibility due to the failure of a third person, മൂന്നാമതൊരു വ്യക്തി. So contract is entered into the promisor. When the contract is entered into, the promisor might have relied on the performance. A promisor ഒരു third partyയുടെ പെർഫോമൻസിനെ എന്ത് ചെയ്തു വിശ്വസിച്ച് അയാളെ കൊണ്ട് പെർഫോം ചെയ്യിക്കാൻ നോക്കുകയാണ്. Even in the case of that third person fails to perform, the contract will not be void because both the parties are sure there. So in such a case, that impossibility due to the failure of a third person cannot become a doctrine of supervening impossibility or cannot be discharged the contract. Then self-induced impossibility. Self-induced impossibility. When the impossibility is due to the default of the contracting party himself, the doctrine of supervening impossibility is not applicable. Means self-imposed, self-induced due to the default of the contracting party. ആരാണോ അതിനകത്ത് ചെയ്യേണ്ടത്, due to the default it gets happened, then this doctrine of supervening impossibility is not at all applicable. Then fifth point, strikes, lockouts and civil disturbances. So the strike or the lockout occurs, then these events do not excuse a party from the performance unless there is a clause to that effect in the contract. So അതായത് ഒന്നെങ്കിൽ സമരങ്ങൾ അല്ലെ ലോക്കൗട്ട്, then civil disturbance, ഗവൺമെന്റ് പരമായിട്ടുള്ള സിവിൽ പരമായിട്ടുള്ള ഡിസ്റ്റർബൻസസ് ഒക്കെ ഉണ്ടാകുകയാണെങ്കിൽ, then in such a case these events do not excuse a party from performing its contract. And failure of any one of these, so any one of these means difficulty in performing the thing, or the commercial impossibility, or the impossibility of the failure of a third person, then self-induced impossibility, as well as the strikes or lockouts or what is that? The strike or lockouts or civil disturbances occur. So today we see what all things: discharge by performance, discharge by agreement. Then third one is what? Discharge by impossibility of the performance. Discharge by impossibility of the performance, and there is the doctrine of which impossibility? Supervening impossibility. And there are some exceptional cases regarding to the supervening impossibility, as well as what is that? There should be situations where this discharge of a supervening impossibility to be prevailing. So hope you understand the class today. Please let me know if anybody of you having any doubt. Please clear the doubt as and when occurred. So thank you for the day.